So this video is the first of two videos for today. I'm also going to work on a video where I have a look at another interview with one of Stearns' friends. This is his former best friend, Chase, who I think we've heard about. We've heard Deb and Chris mention Chase, and we've heard the name knocked about a bit. He did a call-in with Gray Hughes, and I'm going to have a look at that and see if there's anything we can learn from that. This video, however, I wanted to focus back in on this case, basically. And there's a new motion. Now, first of all, for anyone who is curious, the motion count to date stands at this. For the CSAM case, there are 3 regular motions, 2 motions to continue, so that's 5. For the other case, there are 68 regular motions and 1 motion to continue. So without the motions to continue, that makes it 71 regular motions filed by this Beth Borden, who I like to call Lizzie Borden. Sorry, bad joke. So 71 motions filed. It's just becoming a joke. And then she claims that she needs a continuance because there hasn't been enough time to prepare for the CSAM case. Well, that's a heck of a lot of hours right there that could have been spent. Now, there's a number of concerning motions that she has made, and I do want to talk about 2 particular ones which to me are just the most interesting, basically. First of all, there is a motion for the closure of all pre-trial proceedings, and that is in relation to the DP case. And then there is also a motion for introduction of a jury questionnaire, which has been specifically written by the prosecution. So I'm going to just quickly go through and find out why they want to close all proceedings. And then I'm also going to read through a standard jury questionnaire and then follow up with the questionnaire that is being proposed by the prosecution, because to me it's quite interesting. So this motion is for the most immediate case, the CSAM case. Comes now, the defendant moves this court to enter an order closing all pre-trial proceedings in this cause to the press and public. In other words, when they're going through the motions to have the phone evidence struck, the Google evidence struck, all that, they want that to be closed to the public. Grounds in support of motion. Mr. Stearns is charged with multiple counts of S battery on a child under 12, S battery with a child in 12 to 18 familial custody authority, lewd or lascivious molestation, and unlawful possession of material depicting SP by a child 10 or more images. This case has been the subject of unprecedented and highly prejudicial publicity and media attention in Osceola County, adjacent areas of Osceola County, a majority of the state of Florida, outside of the state of Florida, and even internationally. I don't know about unprecedented. There's plenty of cases that get just as much attention. Highly prejudicial publicity. Well, you know why? Because the guy is guilty as. The guy did some pretty horrific crimes. So, tough. Can I just point out too that this is a sunshine state, so I'm pretty certain this motion won't fly. At every court proceeding, however minor or inconsequential, there has been excessive coverage by the press as well as social media users on YouTube, TikTok, Twitter, now called X, and Facebook. And she'd know about that, wouldn't she? Because this is a lawyer who finds it quite acceptable to make herself a social media celebrity. So if you can't handle the heat, get out of the kitchen. It just seems ironic that she's talking about social media interest in the case and that she's coming down on it when she makes a spectacle of herself. It is anticipated the press will continue to be active and aggressive in the coverage of all events and proceedings in this case. Yes, they will, and do you want to know why? Because it needs to be shared. We need to tell Maddie's story to make sure that there are no more victims in the future like Maddie. Counsel for Mr Stearns intends to pursue numerous pre-trial motions of evidentiary and legal significance to the preservation of Mr Stearns' right to a fair trial. So why shouldn't we be privy to that? The types of motions Mr Stearns expects to pursue include, but are not limited to, motions to suppress, motions to exclude evidence, motions in limine of irrelevant and prejudicial testimony and evidence, and many other motions. This woman is full of motions. Which could include a motion for a change of venue if the media coverage of this case continues as it has, so that Mr Stearns cannot receive a fair trial in Osceola County and most of the state of Florida. So they want to move it out of Florida. That's a joke. Please tell me if there is any precedent ever for a trial being moved to a completely different state. Because legally, that's just a whole different can of worms. This woman is tripping. Counsel for Mr Stearns has already filed 3, and then 3 in brackets, motions to suppress, which various media users have read, dissected and commented on extensively. Guess what? That's what I'm doing right now, because Beth, or Lizzie, I think I prefer to call her Lizzie, that's because, Lizzie, your motions are a joke. These motions will require testimony and discussion of the evidence in this case prior to trial. In some instances, this could involve evidence which may later be found to be inadmissible. Included in these discussions of Mr Stearns' evidence will be Mr Stearns' statements to the police, the medical examiner's findings, and potentially discussions on evidence related to statements from minor children. Public dissemination of these items of evidence will prevent Mr Stearns receiving a fair trial. Public discussion in the press in the form of news stories, polls, letters to editors and editorials will lead to an environment which will preclude Mr Stearns from being afforded a fair trial in Osceola County and most of the state of Florida. Counsel for Mr Stearns feels there is no suitable alternative measure to protect Mr Stearns' right to a fair trial under the United States and Florida constitutions other than closure of all pre-trial hearings. To that I say, BS. Honestly, what a joke. You do the crime, you do the time, so they say. There is already so much information available via FOIA that closing the sessions is really going to make no difference to what's being discussed out there. Probably it would simply escalate discussions because you'd have a heck of a lot of media and social media personalities who would be extremely pissed off and would find other angles to discuss with this case. because many of us are just determined to make sure that we follow this through and see justice for Maddie. Now, as I already mentioned, it is standard practice for there to be a questionnaire for potential jurors. When you're called up for jury service, then chances are you're going to get a form in the mail with a questionnaire that you have to fill out. Even here in Australia, that occurs. So last year I got called for jury service. I had to fill out a questionnaire for that. It's no different anywhere. It happens in Florida. So they're making a motion here for a jury service questionnaire, or for a jury questionnaire. And my first thought was, well, that's a bit odd, because doesn't the jury have to do a questionnaire in the first place? So let's find out what's going on here. The defendant states the following: Mr. Stearns has been indicted for first degree M, and which is what this motion is from, I should have mentioned, and the state has filed a notice seeking the DP. In light of the charges and alleged facts of the case, along with the state's intention to seek the DP in this case, the jury selection process will become more complex and time-consuming than in a typical criminal case. Mr. Stearns has requested individual voir dire as to pre-trial publicly availability and hardship issues that could result due to the expected length of the trial, and the prospective jurors' views and beliefs related to the DP. There are often feelings and experiences of jurors relating to other issues that are highly sensitive and personal, which a juror may not feel comfortable bringing up in the presence of prospective jurors. A questionnaire provides a method by which a juror may give initial responses to important questions relating to juror qualification, without the embarrassment of having to articulate those answers first in a room full of others. The first response given by a juror to these questions is often the most candid and telling, and a questionnaire preserves that first candid response, which has been given without any outside influences or pressure, either real or perceived, from other jurors. The questionnaire would enable the court and counsel for the defence and the state to be aware before verbal questioning of sensitive issues and answers which might prejudice other jurors and which might cause a mistrial if discussed in the presence of the entire panel. The questionnaire would include questions relating to the general background of the juror, as well as questions regarding DP views and exposure to publicity or other knowledge about the case. Obtaining this information in written form at the beginning of the jury selection process will save the time normally spent by the court and the parties eliciting such information separately from each juror. The questionnaire would reduce the amount of time used by attorneys in questioning the jurors by providing them with substantial information about each juror in writing before the verbal selection process actually begins. The prospective jurors should be sworn by the court to answer all written questions truthfully and completely, and the questionnaires will become part of the permanent court record and part of the voir dire in this case. Use of such a questionnaire has been proven to be helpful in other cases for the purposes stated above, and a considerable amount of time can be saved by using such questionnaires. Mr. Stearns' state and federal constitutional rights to a fair trial and due process and the effective assistance of counsel will be aided by the use of this questionnaire. Adequate voir dire is also necessary to ensure that Mr. Stearns receives a fair trial and impartial jury that is not biased in favour of the DP or otherwise unfairly biased. Now, on the surface, it seems like a logical motion to put forward. But when I thought about it, to me it sounds like another attempt by the defence at censoring, at controlling who's on the jury more than just their 3 strikes that they are allowed during jury selection. So what I wanted to do was have a look at the standard questionnaire that jurors in Florida receive and see what she has proposed in her questionnaire. So this is your standard questionnaire. Of course, you're going to have the usual stuff: name, residence, date of birth, sex, occupation, and then obviously it's important to know if they understand English, because you don't want someone who is only a Spanish speaker serving on a jury when it's all going to be in English. Do you read and write English, the English language? Sometimes jurors need to be able to read things that are in front of them. So that's also crucial. Then you have you ever been convicted of a crime and not restored to your civil rights? What does that mean? So if someone has been convicted of a felony, then they may lose their civil rights, so they may not be able to vote, hold public office, serve on a jury, or possibly possess firearms. And to have their civil rights restored, then sometimes that just occurs after a period of time, or they may actually need a pardon from the court, so they may have to go through a process where they go to court to have their rights restored. So obviously, if they haven't had their civil rights restored, basically they're not allowed to be on a jury. And then if yes, state the nature of crimes, the date of the convictions, and the name of the court in which you were convicted. So that's just standard. Are there any criminal charges pending against you of which you are aware? Again, last thing you need is a juror who's going to be arrested partway through the trial. If yes, state the nature of the charge and the name of the court in which the case is pending. 8. Full-time law enforcement officers and law enforcement investigative personnel. Florida statute provides that any full-time federal, state or local law enforcement officer or such entities' investigative personnel shall be excused from jury service unless such persons choose to serve. Do you choose to serve? So this is basically only a question for those people. List any official executive office you now hold with the federal, state or county government, and they put a line there to put down what county. And that makes sense too, because you need to be pre-warned in case a juror has a pecuniary interest in a case. You don't want a juror who is basically indirectly connected to a case. So yeah, that makes sense. Is your hearing good? Is your eyesight good? Well, that's important too. The court may require a medical certificate. Do you have a physical or mental disability that would interfere with your service as a juror? If yes, state the nature. The court may require a medical certificate. Do you know of any reason why you cannot serve as a juror? If yes, state the reason. 13. Expectant mothers and parents only. Florida statute provides that any expectant mother and parent who is not employed full-time and who has custody of a child under 6 years of age upon request shall be excused from jury service. Do you want to be excused under this provision? If yes, what are the ages of your children? And then, this is not a summons for jury duty. If your name is later drawn for jury service, you will be summoned by the clerk of court by mail. This form does not use a caption as shown. It may be headed with the designation of the jury authority charged by law with the selection of prospective jurors. So it's a fairly standard jury questionnaire, and it covers all the things that would normally exclude someone from jury service. So let's have a look at what our friend Lizzie would like the jurors' questionnaire to look like. Yeah, I know, the joke's getting old. I will go back to calling her Ms. Burden, or maybe just Beth, because that's going to be easier. So the defendant, Stephen Stearns, through undersigned counsel, submits the attached as a proposed jury questionnaire. Okay, so you have name, juror number, gender, date of birth, place of birth, If you were born somewhere other than the US, have you become a United States citizen? Now, that is actually important because if you are not a citizen of the United States, you can't serve on a jury. What city do you live in? How long have you lived at your current residence? So, you need to have actually resided in that judicial district for at least 1 year to serve on a jury. So, I would imagine that those two questions in terms of citizenship and residency would be something that would have to be established before a summons is sent to someone to serve on a jury in the first place. But anyway, these questions are what I would consider to be acceptable and standard. Here's where I question the need for these particular questions here. It seems a little bit too probative to me, but I don't know. Maybe these are standard questions that are actually just asked within the normal process in the courtroom. So, marital status. List the occupation of your spouse or spouses or significant other or former spouse, significant other. Why not just list the occupations of every person you've intersected with over the past 20 years? You know, you're going to get jurors who come from all sorts of backgrounds. And I think, is it really necessary to be this probative? I don't know. If you have any children, please state name, sex, age, education, occupation, marital status. Also, I think possibly a little bit too probative. Let me know your thoughts. What is the highest level of education you have completed? I think that's a poor question to be asking of jurors because it can cause embarrassment, but not only that, I'd imagine that there are people out there who, in terms of a jury questionnaire, if they've not completed high school, are still going to say that they've completed high school. So what's the point? And asking something about a level of education doesn't actually look into the reasons for that level of education. It is making a judgment on someone's intelligence, basically, and it can potentially be discriminatory against people depending on their social economic status. Just my thoughts. Please specify all degrees, certificates, licenses and major areas of study, along with name of institution where earned. Yeah, see, I would be uncomfortable with that straight up, because what if the defence then looks at someone who has put down that they are a qualified teacher and decides, well, we don't want them on the jury because they're going to be against Stearns. They're going to be in favour of Maddie. Are you currently employed outside the home? Yes or no? If yes, what is your occupation or former occupation if retired? Name of employer. Will your employer continue to pay you while on jury duty? Now, I think that people can claim financial hardship as a reason for exclusion from jury duty, but is it necessary to put all these details? Have you ever had any training, education or jobs, or have you ever done any work in the following areas? And then you have this extensive list: pathology, victims of crime, counselling, law, genetics, DNA. Just so much here. The only thing that's absent is probably education. You've got medicine, nursing. Well, doesn't this negate the whole purpose of having a jury? When you want a jury, you want a spread of people from different backgrounds. And I think this is just a little bit too probative, a little bit too invasive. If I was going to be up for a jury service, unless it directly related to the case, then I wouldn't want to have to say what my profession was. Okay, so you have that case at the moment about the teacher who had a baby from a 12-year-old boy. Obviously, from the jurors, you would probably want to exclude other teachers. I get that. But all this, it shouldn't matter. If someone works in one of these areas, they can elect to be excluded because that comes under the investigative side of law enforcement. But it should be up to them, up to their discretion. These are all professionals who you would think would be able to act in a professional manner as a juror. Selection should not be based on their profession, just in my opinion. If yes to these, please explain. Have you ever studied, read books, articles, or watched programs concerning DNA analysis? If so, what? Oh my gosh, you're joking, right? I would have to write an entire essay were I to explain the amount of research I've done on DNA, the amount of things I've read on DNA, books that I've read which have passages talking about DNA, articles I've read. Like, I'm sorry, but this should not be relevant, because if you are going to have in expert witnesses, they are going to explain things for a jury anyway. All I can see here is an attempt to basically exclude intelligent jurors. Maybe I'm wrong. Have you or anyone close to you ever been a victim of a crime, been charged with a crime, been convicted of a crime, sued someone, or been sued by someone? If yes to any of these, please explain. Again, I think that's a little bit too probative. I think there needs to be qualifications. So in this case, you would want to find out if there's any jurors who have been convicted of crimes that are similarly related to what this trial is about. But to have all of that, a little bit invasive, especially, like I said, I can understand some things you would want to know, but if their civil rights have been restored, provided that they are not someone who has basically been convicted for a similar kind of crime, then yeah, I do think that at that point in time you are becoming a little bit too invasive. Surely, although I can understand why this would be a good thing to put in a questionnaire rather than to openly ask jurors in the voir dire process. So I get that. Okay, do you have any health concern including impaired eyesight, impaired hearing, require frequent medication or frequent breaks? Yes, no. I can understand that question. If yes, please explain health issues. Have you any prior experience as a juror? And then you've got the options there: civil trial, criminal trial, grand jury, or no. If yes, were you the foreperson? If yes, did the jury reach a verdict? Again, I think this is a little bit too probative, asking what the verdict was that was given by the jury. This is a veiled attempt at censoring jurors. They basically want to make sure that they don't have a juror who is likely to convict. Are you related to or acquainted with any employees of the State Attorney's Office, the County Attorney's Office, the Office of the Public Defender, a private attorney's office, or any law enforcement agency, police department? So, do you have any connections whatsoever with lawyers or police? Oh my gosh, you kidding me, right? If yes, please explain. Now, that said, I can understand if you want to remove any jurors who have close family connections to the trial. But any connections with law anywhere? Any connections with police anywhere? Really? Have you or anyone close to you ever been employed by any police force? Yes, no. If yes, indicate who the person is and the area of law enforcement. Have you ever known anyone who has been a victim of a homicide? Yes, no. If yes, please indicate your relationship to the person. That again is somewhat personal, I think. I can understand the reasoning for these questions, but I think these are poorly worded, and I think, personally, I think that during the voir dire process, it should be possible to word questions in such a way that it is not too confrontational for jurors, prospective jurors, to provide answers. Putting it on paper does become a little bit more probative. I'm two ways about this questionnaire. I think at this point in time, I would want to know what the state think of this questionnaire. I think there are parts of it that they would not agree with, and I would have preferred were the motion to state that the questionnaire be something agreed upon between the defence and the prosecution. Now, see, were I answering this questionnaire and I came across question 19, have you recently suffered the loss of a loved one? My answer there would be, this is none of your business. 20, please list all groups or organisations in which you participate or are a member. Service clubs, volunteer activities, neighbourhood groups, self-help groups. Again, bit too probative if you ask me. Have you or anyone close to you suffered from any type of mental illness? Well, I don't understand why it should matter if someone close to them has suffered mental illness, other than it seems to me that must indicate that this is a path that they are going to attempt to take when it comes to Stefan. If yes, please state the nature of the mental illness, and if not yourself, your relationship to that person. That is deeply personal. And I think that sort of thing to be put on paper, it's very different putting it on paper than actually simply answering during the voir dire process. And I don't think it's necessary to be all that specific. You could ask, do you have a history of mental illness which may impact on your ability as a juror? But to be really specific like that, I think that's crossing a line. Now, I think 22 probably is a fair question. During the course of this trial, you may be expected to view crime scene photographs of the deceased victim. How would you feel about that? I don't know about how would you feel about it, but I would be asking in terms of mental health issues, is this something that you have that may cause considerable mental health concerns for you or something like that? I think most people would feel the same way. They wouldn't want to see the images, but they would accept that they have to do so. Please tell us your feelings about the death penalty. Well, that's going into a really murky area, isn't it? This trial is expected to last 4 weeks. If this causes you hardship, please explain. So, a lot of these questions I think are fair questions. Some of them I think are just a little bit too probative for my liking, and I think are a little bit unnecessary. But I'd really like to know what other people think about this. It just seems to me that this is yet another attempt by the defence to try and control every single aspect of the trial. They're basically trying to tell the judge how to do their job. They're trying to have more control over jury selection than the state, which obviously would lead to a biased jury, and I think that's a little bit unsettling for me. And they're basically trying to stack everything up in favour of Stearns. Just trying every motion they can think of just to try and reduce the possibility of Stearns being convicted. Now, I know that it's their job to file all these motions, but 70-something motions, all pretty much along the same line. They're either trying to control the jury, trying to tell the judge how to do his job, or trying to keep the public out of the trial, or basically trying to control what evidence can be used. I would like to see the judge at some point in time put his foot down and say to this woman that she needs to be a little bit less overzealous with these motions, because she's making the process look like a joke, in my opinion. So I'll leave it at that. Thanks for listening. Keep an eye out, because the next video will also be coming out very soon after this one, which will be me looking at an interview with Stearns' friend Chase. So keep a lookout for that. That will also be following behind this one, not too far off. Thanks for listening, and I'll catch you in the next one.